Kia ora, my name is Katrine Evans. I'm in private practice these days with Hayman Lawyers. I was formerly at the Privacy Commissioner's office for quite a long time, so I know most of you from there. This session is going to be on compliance notices under the Privacy Bill. Bring out your questions. How are they going to work? What is it that they're there for? Are these things going to have unintended consequences? How are we going to deal with them? And a question that I'd like to throw out for you to think about right now is, what is your agency doing to prepare for these changes in the Privacy Bill? Those of you who know me will know that I can talk all day, so I can stand here for an hour, or you can chip in with questions. I'd prefer you to chip in with questions. Stick your hand in there if you've got one. Anytime, just stop me and we can have a talk, and we'll throw out questions for the rest of the room as well. So if you do have a question, standard rules apply. Put your hand in the air, wait for the microphone, and then that can come through so that other people can join in with the conversation. I thought I would start with a little bit of what happens now, the current powers of the Commissioner. So we know the bill is introducing these new powers, compliance notices, and in our concurrent session, access determinations. So what does the Commissioner actually do now? What can the Commissioner do now? Suggestions from the floor. Actually, you don't need to wait for the microphone. I'll just repeat it back. What can the Commissioner do now? Not much. Okay, because? Okay, so there's not a great deal of firepower in the Act. There's not a great many teeth that the Commissioner has. Does it kind of look something like this? Is John in the room? Please, is John in the room? Dang, where's he gone? Okay, so this is probably a slight exaggeration, right? But the Commissioner can receive complaints, investigate complaints. What can he do off the back of complaints? Make recommendations. Name agencies. Now that's quite tough. I wouldn't underestimate the power that can have to actually, one of the questions with any of these new powers is, does it provide incentives for agencies to act differently, to comply with the law in a different way? And certainly the naming policy that was introduced a few years ago, I think my impression from outside has been that it's actually made quite a big difference, that it's something that agencies are often aware of and wary of. Can the Commissioner act when he doesn't have a complaint? There's a few shaking heads. There's a few yeses. All right, somebody who answered yes. Okay, Commissioner can do an own motion investigation. Yeah, so under 13M of the Act as it stands at the moment, the Commissioner has a function to investigate issues on investigate matters that may breach privacy on his own initiative. And that doesn't need to be a breach of the privacy principles. It's a wider kind of function to look at privacy more generally. And that is also reflected in Part 8 of the current Act, which says, okay, so the Commissioner, how does the Commissioner go about that kind of investigation? So own motion investigations are certainly very much a thing. And, so in the past, the inquiry into MSD and the collection of individual client-level data was a good example of an own motion investigation from last year. In the past, we looked at things like Google Street View. We had a look at health insurer policies of getting sort of 5 years' worth of medical notes regardless of what happened to be in them. So there's been a variety of inquiries over the year, possibly not as many as you might expect. So maybe this is one of the areas in which compliance notices, one of the policy reasons behind it is that the Commissioner can intervene in these kind of more systemic, broader-ranging things, as Paul Roth mentioned in the previous panel, those things that don't necessarily cause harm at an individual level, but that are problematic at a systemic level. All right, is that, it is legible, good. All right, so complaint investigations, own motion inquiries, but off the back of that, you get recommendations. So the Commissioner does have an existing power to refer, function, power? Yeah, All right, let's not get tangled up in legalisms. An ability to refer matters to the Director of Human Rights Proceedings where a matter doesn't settle, or where you've conducted no motion investigation and the agency, say, does not want to comply with your recommendations. You can actually refer matters to the Director of Human Rights Proceedings to push things through. He considers whether to take it as a plaintiff into the Human Rights Review Tribunal. So there is an angle, even now, to get matters into court, but it is quite a lengthy process. And I think that's potentially one of the advantages that we can talk about with compliance orders. So the naming policy I don't think you should forget about the Commissioner's existing powers to demand information. So Section 91(4), for example, the Commissioner can issue a statutory demand for information that he considers may assist an investigation or an no-motion investigation. And it's an offence to fail to provide unless you have a reasonable excuse to do so. Quite common in access complaints, cough up your information and you have to provide it to the Commissioner, even if you have statutory secrecy obligations that say, generally, I don't give this stuff out. You've still got to provide it to the Commissioner, who will then protect that information under his secrecy provisions, will protect any privilege that applies to the information, but nonetheless, he can then use it to do his investigations. And the Commissioner can also take evidence on oath. So that broadly is a picture of what happens now and how the enforcement regime operates now. Commissioner looks at things, complaints, own motion, can refer things to the Director to put it on a litigation track if required, but in the meantime has all these other things that he, or previously she, hi Marie, can do. All right, what's wrong with that? I subtitled this presentation Cave Canem. You may notice a theme starting to emerge. Okay, so what's wrong with that current position? It works, doesn't it? What's the gap? Yeah, Marie's saying us. Yeah, so toothless tiger. Yes, Marie is very much a cat person rather than a dog person. I can attest to this. But yes, when the Law Commission was reporting, that's exactly the phrase they used. The Commissioner is a toothless tiger. Not entirely. That. I'll come up with a kitten picture next time, Marie, I promise. But beware of the cat, doesn't quite work in the same way. All right, so the Commissioner really doesn't have that many teeth. And say incentives for agencies to behave better. A lot of our agencies, I mean, we're here because we care, most of us, are probably here because we care. So we're already thinking about this. Our agencies that have committed to sending us here are already committed to doing something about privacy, even if we're still feeling our way about what that looks like. At least we're on a path. But there's an awful lot of agencies out there that have no idea, no clue, don't necessarily behave responsibly. Who's going to make them? And the Commissioner somehow has got to make them. And recommendations just don't cut it. At board level, you want to know what's going to happen. What's the worst that can happen to me? So, yeah. What else is wrong with the current picture? Slow, yeah, it is slow. Because what has to happen? The Commissioner has to investigate. If the agency won't play ball, you've got to go through the Director, who then has to give the agency a chance to have a say, realistically, examines it all under, with his own hat on as well, exactly as he has to do. That takes time. And then we've got to get it into the tribunal and file proceedings. And if the Director decides not to the Commissioner decides not to refer it, or the Director decides not to take the case, then it's down to the complainant to get matters back into the tribunal if there's a complaint. If there's a no-motion investigation, it's going to fizzle, right? So it doesn't necessarily go anywhere, and it's slow. That actually takes considerable amounts of time. we've got a middleman in there. And absolutely no disrespect to the current director, Robert Key, when we're talking about this, or indeed to the tribunal when we get round to that. All right, so what happens when you have serious breaches that an agency is unwilling to address? What happens if you have those systemic or repeat breaches where there's been no progress made? So people say, oh, yeah, we're doing something about it. But you can't actually see that happening. You do get agencies that will try to game the delays and game the investigation process. Not necessarily that helpful. None of you would do it, I know, but believe me, it happens. And you have to use a middle person in the enforcement process, so that's additional time and resources. So some of these are these are the principal policy reasons why the Law Commission came up with this idea about we have to get away from this toothless tiger process that we have at the moment. We've got to give the Commissioner more teeth. Yay! Actually, I should say 3.0, Marie, shouldn't I? Privacy Commissioner. All right, the watchdog. Yes, we're going to be the watchdog. We're going to have lots of teeth. Is that actually what the bill delivers? I think is the next thing that I want to have a look at. Sorry, this is a lot of text. Don't scribble. This is just by way of a map of the kind of things that are in the bill that we need to start to think about, and maybe this will prompt some of your questions. So Section 124 talks about when the Commissioner can issue a compliance notice, what the Commissioner has to consider, what's that kind of process that you go through, what kind of a say does the agency have in the process as well. There are various rules, as you would expect, with a new kind of legal mechanism. I'm delivering a notice that's enforceable in some legal forum about what form and service requirements are. What does an agency have to do? It's kind of that so what question. The Commissioner issues a compliance notice, so what do I do? And the answers lie in the next sections about variation. You can apply to vary or cancel the notice. The Commissioner's normal powers to obtain information apply. The Commissioner, if you do nothing, and we'll get on to this, can enforce the compliance notice or a decision on variation if the agency does diddly squat, which will happen occasionally. You need a mechanism to deal with that. But if the agency genuinely disagrees and wants to do something about it, you need that appeal provision. And so there are appeals, and we can hopefully discuss that in a little bit more detail about what that's going to look like. Appeals against compliance notices or variation, cancellation. The question always comes up, so I've got this compliance order. What do I have to do? If I don't agree with it, if I want to lodge an appeal, does the order keep on going? Have I got to comply with it? There is a process in here for applying for an interim order to the tribunal, which the chairperson will determine on suspending the notice, pending appeal, and then there are various issues on remedies, costs, and enforcement. So that's the legal gobbledygook. Let's have a look at how it will work in practice. Ideas from the floor here, because I think there's a genuine debate to be had about what you think would drive better practice in your organisations. When will the Commissioner issue a notice? Do you expect him to do it as a routine matter, wherever there's a breach? Or do you think he should save compliance notices in his back pocket for those kind of real special cases, those hard questions? And here's where I'll ask our microphones to come across, I think. Somebody give me a star out of a 10. Yes, down here, thank you.
Thank you, Matthew Andrews. I think like if there's a toolbox, and some of it's the hard legal power stuff, there's always the power of persuasion. Yep. With that sitting behind. I don't know whether any people from IRD here, but they're excellent at issuing notices, requesting information, knowing that they can actually, without necessarily citing a statutory justification, knowing that they can actually request it. Okay. I also just have perhaps this is a sort of almost a question back at you. Coming from the public sector, I mean, I understand the policy drivers for compliance notices, but there are, as there is with the OIA and the Ombudsman, there are other things that work for the public sector, the reputational impacts, the select committee process, and privacy isn't always top of mind for select committees, but it's certainly part of the standard sort of suite of questions that you have to answer. So, you know, there are other things, some within the Privacy Commissioner's control under this new system, but some that exist outside that. So, to me, there would be, it wouldn't feel like a routine thing. There would have to be a threshold of discussion first, and perhaps a lack of engagement or a genuine disagreement before you got more into that.
Right, and that's a great start of the discussion. Those who are in public sector agencies here, do you agree this is kind of another, oh my goodness, you already have all these reporting accountability obligations, you're going to get this on top. Is that going to be problematic for you? I think this will come up as part of the mandatory breach notification discussion as well, because you know, there's an offence for failure to notify, but offences don't apply to the Crown unless, you know, because there are all these other incentives on them to behave properly as well. And so it doesn't apply to the Crown unless the legislation specifically says that the Crown will be liable for a criminal offence. So I think you kind of get those kind of policy discussions about, don't we have sufficient incentives in there as well? Agreement, disagreement? We've got one over here. Or a different point.
Sort of feed in a little bit. Would it, I guess from my point of view, there's the question of precedential value.
Yeah.
So to what extent would these compliance note, because if you're linking in with a complaint or a specific issue, there's always going to be the particular issues at the back of that. But if you can't separate out the specific issues from the sort of the precedent and the thing you want to drive, the behaviour you want to drive going forwards, then how much use would the notice be beyond the specific incident?
Right. Again, an excellent point. Is it just dealing with the individual situation, or are you, particularly by the time we start talking about systemic breaches, you think there's probably other people in the same category, so you would want the compliance notice to have some sort of wider value. It's only something we need to think about when we're thinking about commissioner-initiated inquiries, for example. When do you go into that, which is actually quite resource-intensive and burdensome? You know, stuff like when there's serious harm to address, when you've got a wider ability to have an influence, and the naming policy uses similar kinds of language. You know, you don't just go out and name everybody. It's like, what are you going to achieve by doing it? So you get some similar questions here. I think you're right with compliance notices. And your other point is, you know, can you take it out of that individual situation? Can you actually make sense of it? Is the notice itself going to tell people anything? Which presupposes that you're going to publicise what's in the notice. I think that's one of the questions. If the Commissioner issues a notice, that ties in quite nicely with that naming policy. If you get to the stage of getting a notice, are you going to be publicly named or not? Yeah. I don't have answers to all these questions because we don't know, because it's just the bill. And John's not here. Put him on the spot. Now, these are all things for the office to work out, right? Cool. Other questions? Yes, Jane.
Katrine, when you look at the provisions and how it might be different, I don't know much about tax law, unfortunately, otherwise I might earn more, but whether they actually discuss the notice with you before they issue it, because the bill has those provisions around you actually the Commissioner has to have a discussion effectively about what the terms of the notice is going to be.
Yeah.
And just a comment about it, I think that potentially, well, of course the Commissioner has to act as a reasonable decision maker, but it's nice in a sense that it's very flexible, and so you have the thing, there's some must, what the notice must have, and then there's quite a lot of may, and it's leaving that space for it to be, I think, quite generic, and I'm sort of just hypothetically thinking that might be where you have a mandatory breach notified and you've got some sort of problematic agency and you don't, they're not really dealing with you and you don't know, so you can almost say, fix it. About your comment about, if you want to comment about that.
The comment about sort of the checks and balances and the ability to comment on, say, a draft of the compliance notice, I've got that later in the slides as well, because I think it's important to look at how will the Commissioner actually use these things. What are your rights as an agency? What are your rights as a complainant? If it's a complaint type situation, do you get to see these things? How much? And the bill doesn't actually answer the complainant part of the equation, but it does talk a lot about what agencies' rights are. Before they're faced with a compliance notice, exactly as you would expect, again in line with the Bill of Rights Act and natural justice, also just good administrative and reasonable practice. So you would hope it would do it anyway, but it's legislated for. The potential uses of these things, that your mandatory breach notification one is potentially a good example. And I think it's really useful to come up with, some examples of how would it work in this situation? How would it work in this situation? So a breach that you haven't notified when you haven't told the individual when you should have told the individual, and the Commissioner kick in. Other questions? Yes, in the middle. Thank you.
Yeah, hi, Katrine. I was just thinking about the uses of it and thinking about the problems that we currently have with powers existing. And I think one of the things we didn't talk about, while we look at what powers there are under the Act, there's also the power of public opinion, and obviously being a government agency as well, the sort of political risk as well. And I think exercising that power from time to time may be more persuasive than putting in place another process that maybe some might just put into delay tactics again, because you could see how this could be used in that way. And so if one of the issues is about the speed of enforcement, and here I'm thinking about for an individual, maybe that's where compliance notices are best used in terms of trying to get a result for an individual and not requiring them to go through a long and elongated court process.
Right.
Whereas when you're looking at more systemic issues and you maybe are talking about large dollar implications for large companies, the power of public opinion and the media may be a better avenue than going through an extra process like this, but just a thought.
Yeah, or a compliance notice may be a tool actually to trigger some of that public debate. Say if the compliance notice, for example, is made public. What do you think?
Maybe using them in tandem as well, but we shouldn't lose sight of the ability to use public opinion to try and make change as well.
Yeah.
So,
yeah. No, that's very true. As the gentleman down here referred to a toolbox. So I think that's a really good way to look at it, is one tool in a toolbox. How will it be used? I don't know. It's highly discretionary. So the Commissioner can basically do whatever the Commissioner at the time wants. You would expect the Commissioner to behave in certain ways. But there are other tools in that toolbox as well for public sector agencies. We've had some mentioned. You brought up the things that actually apply to business as well. So that business reputation, the effect of a privacy breach on your share price is not insignificant, quite apart from anything else. Is this going to add additional value? And I think that's a question that you have to answer in each individual circumstance as well. Because back to your point, the privacy is such as we know from all the complaints that we get, privacy is such a fact-specific situation. Can you actually craft something that's going to have that precedential value, or does it just have the value at the time? Well, maybe that's enough. But if you have a broader appeal, then that's fine as well. James.
James from Internet NZ. So we're a not-for-profit, and we're kind of sitting to one side of government. I am writing a submission on the bill. Just like to tease out something on the idea of using public opinion. In the privacy and human rights contexts, some of the most important interests to take account of are those of vulnerable or marginalised groups against whom public opinion might be pretty readily unified.
Yes.
And so in the business context, where you've got a brand reputation to protect, that's an important lever to wield. And we've heard some people who are leading best practice earlier today making really constructive efforts to do that. But we also need the backstop to protect vulnerable people who might be universally reviled. They still have human rights and deserve the protections.
Yeah. So prisoners would be the classic example of that, particularly those who are inside for particularly nasty things. People still have their human rights, and maybe this is a good way to recognise that, we can't all be driven off, which is not what you were suggesting, I know, but we can't be driven purely off that court of public opinion. Yeah. Yeah. Gotcha.
Just before you move on, just a comment on when it should be used. Davin Warner, by the way, sorry. On behalf of my private sector clients, I think there's a slightly different angle to look at this. I think a lot of private sector organisations would hope that the Privacy Commissioner will use compliance notices more often than not, because internally, when they're trying to deal with a privacy complaint, they've got to persuade the board, the executive leadership team, bunches of other people, managers who don't want to do anything, don't want to settle, don't want to listen, and complaints are often driven away by bad practices at the top in a corporation. So for a privacy officer in a private sector organisation, they're desperate to get a compliance notice so they can take it to the board and say, we have to do this, we have to change our practices. It's what they need.
Davin, that's such an interesting point, and I hope that somebody was going to bring that out. There is merit to a sort of more or less routine use of compliance notices as well. One, it's even-handed. If you don't do the voluntary stuff, you're going to land with this at the end of the day, and everybody's in the same boat, and that's fine. But also, is that a useful lever for the privacy professionals in the organisation to say, we got one of these things, now you have to take it seriously, and gradually that becomes a tool to change the culture in the organisation. Would anybody disagree with that view? John T?
Not entirely disagree with that view, but I wonder what the capacity of the office is to deal with multiple compliance notes.
Yeah.
So when it does use them, one would hope that they are at the heavy end of the spectrum, and that has greater impact. I would imagine that for the office, if it issues too many, then it would become a management problem.
Yeah, a management problem, or perhaps that's where you've got to weigh that up. Is it diluting the effect of them over time? So your point absolutely holds true, I think, but there is that corollary that actually, if this is just seen to be 10 a penny, rather than being actually, you are really in the you-know-what now, maybe there's certainly a practical issue for the office. Looking over at Jane, General Counsel down there. Used to be my job. I'm glad it's not going to be mine under the new bill. So how do you cope with that? And actually, volumes of work through to the Commissioner's office is something, again, that comes up in the breach notification environment as well. How on earth are we going to cope with that and do that successfully? Yeah. Does it have greater impact making them routine? Does it have greater impact making them sort of holding them for the special events? Maybe you can get both somehow. Might depend how you word them, what kind of conditions you impose on them. Yeah.
Katrine, I think there will be challenges for the office in creating what will need to be its policy on enforcement.
Yeah.
For any agency that's got enforcement powers, you'd expect them to develop that and publicise that. The question around, when should the Commissioner use this tool, I think will be highly influenced by matters such as whether harm is established or not, because the bill in its current form gives the Commissioner a power to issue a compliance notice without that important threshold having been crossed. And so I think the office's development of its policy will need to be quite nuanced in the circumstances where, in the absence of proven harm, this kind of enforcement lever is the right one to pick up from the toolbox.
Right, and Paul Roth mentioned this morning the direct marketing example that, when are you going to pick that up? At an individual level, it's actually really hard to show that direct marketing creates harm. At a cumulative level and over time, same kind of thing can happen in the breach environment, actually. But so how do you deal with that as an office? And you're right about publishing the enforcement policy as well. So some overseas commissioners have done that. I think Australia does that, for example. When are we going to do these things? What are we looking at? So very similar to what the Commissioner's done with the naming policy now. you'd expect to see something similar, not putting pressure on anybody. You'd expect to see something similar operating in this environment. That's an excellent point. Sorry? Marie's got an example? Example.
Well, here's an example from my time as Commissioner, which might spark some thinking, and that is that we were dealing with the health insurance industry, naming no names, and the practice in the industry was when medical records were requested from a person's doctor, only the records relevant to the claim would be requested. But there was one or possibly two companies who were standouts from that, only one, and they just refused to comply. They said no, and they sort of made an argument under the Act for it to be legal and all of that sort of thing. So that was the moment when I really wished that I'd had a compliance power. But the more you think about that example, the more risky you can see it might be in terms of subsequent appeals or litigation or whatever. So, but I must admit, in seeking the compliance power, we I had that example in mind, so that I was looking more at the bigger cases. But I can also see that in the case of specific complaints by individuals, there might be a case to use the compliance power just to get, a certain thing fixed. So I would say probably both, like you.
Yeah. So yes, that's a very good example. It's a really clear one. But your other point about you need to think about what your end point is as well. When you enter into this, by the time you've got a compliance notice, you've got variation applications, you've got appeals, you've got enforcement proceedings if the agency decides to stick its middle finger in the air at you. What do you do? So you've got to be prepared to know not only what I'm doing now and that I'm doing it right now, and potential for judicial review, as there always is, but that I'm prepared to see it all the way through so that it's not an empty threat. So my own ideas, yours are much more sophisticated. But just to make the point that it is completely discretionary, there is nothing to stop a commissioner from making compliance notices routine, as long as the process is observed, as long as the mandatory relevant considerations, which I'll flick to, are observed. Most obviously, where there's something obvious to be fixed and the agency isn't voluntarily fixing it, or not acting fast enough, that can be a really good way of cutting to the chase. And where the agency's actions are causing or may cause harm, particularly where that harm is at the serious level. Sorry, I've got a question in the middle here.
Thanks, Katrine.
Kent.
If these do come about, do you see that there may be an opportunity that people will apply for them, or in effect apply for them in replacement for court orders?
That's really interesting. There's not an application process for a compliance notice. You mean a complainant might say, why haven't you gone down that line? Yeah, it could be cause for criticism of the commissioner if the commissioner exercises his discretion, as he may well do, not to issue a compliance notice. That, I think, is where the transparency about the enforcement practice, the enforcement policy, will be particularly useful, so that everybody will be able to understand the way in which this is going to operate. That can be a shifting target over time, but at least being really open about the fact that this is when I'm going to operate them now, within the resources of my office now, and we're going to be focusing on these types of issues, and you might target certain industries, for example, for action. That's going to help complainants as well, because there's undoubtedly, we'll get it with referrals to the director as well. Oh, you found an interference with privacy, we haven't referred it to the director. Well, why not? That's power that's available to you. You're not protecting my privacy sufficiently. That's an easy thing for a complainant to say. And they shouldn't necessarily be subject to, the commissioner shouldn't necessarily be put under that kind of pressure, I suppose. So again, the more open we can be about how it's going to be used, the better. Just moving on slightly. What kind of breach can lead to notice? I think it's worth noting, I do like Doug the dog, I always have. What type of breach can lead to notice? any breach of the Act, and this comes back to Jane's point earlier about about breach notification. If we haven't notified the individual when you were supposed to notify the individual, the Commissioner could issue a compliance notice to make you notify the individual, I think, is the way that I read that section. We tend to think about breaches of the privacy principles, which is fine, or breaches of rules or codes of practice, and that's obviously going to be the principal fodder for compliance notices. It's where you're found to have stuffed up under one of those common sections. But it's any breach of the Act. Is that too wide, I suppose would be my question, or should we be more targeted? The other things on the list are fairly targeted. So breaches of provisions of an approved information sharing agreement, whether a person complains or not, they retain a person's right to complain, but it's not just triggered by complaints. This whole area of law is that it shouldn't have to be triggered by a complaint from our vulnerable people who may not know what's going on, may not be able to complain. Or from just anybody who has better things to do with their day than, sit in a complaints investigation process for the next little while. So breach of provisions of an approved information sharing agreement or an information matching agreement. Excuse me, I'm trying not to cough into the microphone. It'll deafen you. Wrongful failure so the example, wrongful failure to notify individuals of a data breach or to publicly notify a data breach. Interestingly, in here as well, I was going, yay, when I spotted this last night. Breach of a public register privacy principle, you can actually issue a compliance notice for that. Now, you can't get breaches of public register privacy principles into the tribunal. The Commissioner can make various statements, the Commissioner can report to ministers or to the Prime Minister or whatever. But ultimately, that's never been particularly well enforced. These public register privacy principles, which should have been updated in the bill, right, and haven't been, but that's a grizzle for another day. The Law Commission did make various recommendations which haven't been factored in there. They've just been reenacted. But nonetheless, they are there. I think they're honoured probably more in, more in the breach than anything else. So having the Commissioner able to issue a compliance notice for breach of a public register privacy principle is something that's really grunty and additional, which may help to the extent that the principles mean anything and can be enforced. I did say I wasn't going to grizzle, didn't I? What are the things the Commissioner has to think about? Sorry, just to bog you down in details again here. You've got to think about, so this is back to Jane's point earlier about checks and balances. The Commissioner has a broad discretion to issue compliance notices, but it's not unlimited, it's not unbounded, and it's certainly not undisciplined. It can't be. So the Act, I think it's 125, sets out this list of mandatory relevant considerations. The top one, I think, is almost the most important. Is there another means under the Privacy Act or another act for handling it? It's a little bit like that provision in section 71(1) that says the Commissioner can refuse to investigate a complaint if there's actually an access to an adequate remedy elsewhere. This is kind of similar. If there's another means under the Privacy Act or another act for handling that. So, for example, with our breach notification situation, you might decide to smack them with an offence because it's an offence to fail to notify. So maybe it's better to deal with it at the offence level and prosecute. Personally, I have slight qualms about criminal offences in that area, but that's a personal view. But that would be another means under the Privacy Act of dealing with the same thing. So you shouldn't be getting double ups across the Act, compliance notice, and also something else, and also something else, and also something else. And I think that's quite helpful for agencies who will be sitting there and thinking, how many times is the Commissioner going to hit me over the head about this particular breach? Not thinking of any agencies in particular. So is there another means under the Privacy Act or another act for handling it? Our seriousness that we've talked about before. Likelihood of repeat. So again, we're sort of really thinking systemic here. What are the chances that this actually could be repeated? And our precedential value as well. The numbers of people affected, whether an agency's been cooperative. Interesting point. And what the likely costs to the agency are of complying. Now, those are factors that the Commissioner has to consider, but the Act's quite sneaky, or the bill rather is quite sneaky. It says he has to consider them to the extent the Commissioner considers the factor is relevant and that information about that factor is readily available to the Commissioner. So I think with that, it's up to the agency to show its cards, right? In the investigation, the Commissioner says, I'm looking at this thing, make sure that you're really open about it. The Commissioner's got to consider a whole range of factors. Can't consider them if you don't put them in front of him and say, dude, this is relevant. You've got to think about this. And that's going to influence this kind of decision. Will he go down the compliance notice line or won't he? But still, ultimately, you can see a big, fat discretion at work in there. Another slide with too much text on. This is the process for an agency. An agency has a right to have a say before a compliance notice is issued. So they have to have a reasonable opportunity to comment. They need to be told. And they need to be told certain things. They need to be told in writing, which is good, because then you can go and slam it on somebody's desk, right? They need to be told what the breach is, with the appropriate statutory provision that you're said to have breached, the conclusions about those mandatory factors that I just looked at. So that's a discipline on the Commissioner for turning his mind to what those factors are and demonstrating that he has turned his mind to what those factors are. Specifying the steps that the Commissioner considers need to be made to remedy the breach. Not much point having a compliance notice if you don't say, and you got to do this, and you got to do this, and you got to do this. And the dates. So again, not much point telling people they've got to do something if you don't say when they've got to do it by, because then you undercut your potential policy reasons for having the things in the first place, which is get stuff through speedily, don't let people game it, and so on. Interestingly, not all of those have to make their way into the form of the final notice. It's quite similar to the draft, so it needs to be in writing and it needs to specify what the breach is and what the statutory provision is that you're talking about. But it's discretionary as to whether you talk about the steps that you need to take to remedy or the conditions that you might apply to the agency to make sure that it complies, or the dates. I'm not sure. It's interesting. I don't know why it was made discretionary about whether you put those in the compliance notice, because I wouldn't have thought it would be particularly easy to enforce a compliance notice, or well, not necessarily enforcement, actually we'll get on to that, but if somebody's going to appeal against a compliance notice, again, they need to know exactly what they're appealing against. They need to be able to put that in front of the tribunal. You need to be able to say, this is what I was required to do. I would have thought that you'd be much more open to challenge if you didn't actually put those factors in, or those items into the final notice. And of course, you have to tell the agency about the right of appeal. Any questions on any of that? Having bamboozled you. Yep, got one at the top. John T. I told you I can talk all day.
This one's in relation to process. Sorry if you have to go back one slide, but noting that privacy is about protecting the individual,
yep,
if you like, as opposed to the organisation that may be under the microscope. Is the final step in the process just giving a date? Is there no verification step? Is there no checks and balances to actually see that compliance has been achieved?
Good point. The Commissioner does not have audit powers, but the Commissioner could impose conditions on, and I think one of those common conditions will be you have to report back and you have to provide evidence that you have done X, Y, and Z. So I would expect as a matter of course to see that written in, because otherwise you're just flinging a piece of paper out into the ether and you tell people they're going to comply, they say yes, solution, go back to what they were doing before. So you need some kind of verification, I think. It will depend on the circumstances about what's appropriate. And again, you shouldn't have to go overboard, because the cost to the agency can rapidly mount up if you have a lot of in-depth analysis and constant reporting. It's a little bit like the conversation that you have under approved information sharing agreements about what should my reporting requirements be, about how many sharing arrangements have I had, and what's my level of accuracy, and a whole range of other things. That can actually get quite burdensome, and I think you get into the same kind of conversations with this. But yes, having some kind of verification process I think would be really important. Paul.
Is this working?
Yep.
Okay. Yeah, I don't know if I'm barking up the wrong tree here. This is just had
Not to use my metaphor.
Yeah, exactly. That's why I used it. I won't dog you with it though. But yeah, this is in relation to the slide on mandatory relevant considerations. I don't know if this was intentional or if there was a drafting oversight. But you had that list of mandatory relevant considerations. What about Section 14A of the Privacy Act, new Section 18A of the bill, which requires the Privacy Commissioner in the exercise of his or her functions and powers to take into account the following matters, which include interests that go in the other direction and the interest of business and government in operating efficiently. Those seem to be kind of non-legal considerations that would be appropriate to take into account if you're trying to achieve a settlement. But if you're making a decision that has some sort of legal effect, it seems like a bit of a wild card that the Privacy Commissioner will be authorized to play.
So you're saying they should be read into these mandatory relevant considerations? Because I
don't think so.
You don't think so?
I don't think so.
Right. Because they will apply, of course, across the board. That's a general provision across all, exercise of all powers in the Act.
I think that ought to be left out. But the effect of not excluding 14A from any sort of decision that the Privacy Commissioner makes that has a legally binding effect, whether it's a compliance notice or access direction, the law should be the law. You should be following the precedent and whatever. You should be following the mandatory relevant considerations and not bringing in something possibly from left field.
Right. So that would be the right of government and business to, go about their business, their legal business without hindrance. And in the new Act, we've got, the bill, we've got the cultural considerations, and which has now been written in as the Law Society recommended.
Comply with what? Comply with,
Yeah. All right. So should those apply in this kind of situation? Because they do clearly under the bill at the moment. Is there an argument to say they shouldn't comment at the back? Or...
Could that not come under likely costs to agency of complying? Costs don't have to be dollars, do they?
No, it would probably be resource considerations generally, not necessarily just the money at the end of the day. So certainly there's some tie-in because of the likely cost to the agency. So is it picking up the same idea, kind of what's different? Is this a problem?
Just a quick one. Obviously, it's subject to appeal, but is it also subject to judicial review and to ombudsman complaints?
Yeah, always. So those aren't overruled. So the Ombudsman Act applies to the Commissioner as normal, and judicial review will apply as normal. So you have to behave reasonably. I think Paul's sort of coming from the other side of things, about saying actually you shouldn't have to take into account all those things, because if it's a compliance notice, it's talking about a breach of the law. A breach of the law is a breach of the law. By the time you've actually got round to saying presumably you've thought about it beforehand, but before you get round to saying it's a breach of the law, then people should be required to comply. It's kind of slightly circular though, because to get to the conclusion that there's a breach of the law in the first place, the Commissioner has to think about all these other things. It's not just the process of issuing the compliance notice itself. Yeah. The decision to issue a compliance notice as being one tool out of the toolbox that he could select to be able to deal with a particular problem. Before you can even say there's a breach of the law, you've got to think about these other things as well. And again, the policy reason behind that is that privacy is not the be-all and end-all of the universe. In New Zealand, we at least sort of think about it. We like to think we think about it in a relatively flexible way. I won't use the term balanced because I hate it, because privacy always loses on a balance scale to other things. But yeah, it creates some difficulties. It's a good point though. Should you actually, how many hoops should you have to jump through? All right. What are your options if you get a notice? And this gets me into the question of, what are you going to change about, or what are you going to advise your clients if you're in the advisory business? What are you going to advise your clients to change about their current practices to avoid getting one of these things in the first place? But if you do, what do you do about it? And the main thing, I think, is what can you do if you think the Commissioner has got the facts or the law wrong? There's a duty to comply as soon as possible. But you do have some options in there. So you can apply to vary or cancel the notice. So there was a point up here earlier about delays, I think, and an ability to be able to, this is another process under the Act. People will use this to kind of spin things out as well. Here's an option. But it's also a really valuable check and balance, because the Commissioner might have got it wrong. The Commissioner might not have all the information in front of them, might have misunderstood the facts. Here's an opportunity to have something put back in front of the Commissioner to say, we've got to vary this notice, or we cannot comply with it in its current form. If that's what you say, we can't do that. So raise some practical issues. That's your opportunity to do that. It's persuasive. Again, it's up to the Commissioner to issue then a decision about whether to agree with you and vary or cancel the notice, whether to amend it. Sorry, that is variance. My brain's switching off. Or whether to say, yeah, nah, and you got to comply, or I will do something about it. You can appeal against all of the notice, part of the notice, or against the decision about variance or cancellation. Now, that ability to appeal, and I think it's really important for the next section, it can be substantive, it can be procedural, so it can be, I think you have got it wrong. You can look at the merits of what the Commissioner's come up with, either particular conditions, particular sections, or I'm not in breach at all. And you can appeal that to the tribunal. Or you can say, you went about it the wrong way, I haven't had my right to be heard, yada, yada, yada. It can be an appeal on facts. The tribunal can examine the facts on which the notice was issued. Or it can be a legal challenge. So very much as the tribunal operates now, they will look at all the facts and all the potential for legal omissions. And you can challenge the Commissioner's discretion. You can say he didn't exercise his discretion properly, and he should have exercised his discretion in a different way, which is quite an interesting provision to include. Look at that time frame for lodging the appeal, 15 working days. Nothing, admittedly, will be a surprise by the time you get down that track, right? Because you'll have had the opportunity to have a say beforehand. You'll know what's going to be in that notice. You will have had the conversations. So none of it's going to be a surprise, but don't sit around. So I think within agencies, you've got to have a process that's actually really hard in large agencies to kick something through to make a decision about whether you're going to appeal something within 15 working days. I think that's going to be quite challenging. However, just note the bottom point. You can actually apply for an interim order to the tribunal that will suspend the compliance notice pending the appeal, and the chairperson of the tribunal will decide. So you don't have to comply with the order while you're appealing it, which is quite a fundamental point. Doesn't entirely deal with this 15 working days. I think what we'd find probably is quite a lot of applications for variance, which will put something on hold, because then the appeal period doesn't kick in until the decision on variation or cancellation is made. I think we may find quite a few of those, which could, apropos the earlier point, lead to quite a burden for the Commissioner's office if those kind of applications become routine. I'm not sure how else you draft it to get around that point. I think you have to allow agencies these opportunities, but I'm not quite sure how you would draft it to get around that potential for substantial workloads coming in. What not to do if you get a notice. Yeah, don't ignore it. Just don't ignore it. Have a process. Make sure you can get notices up to the right people. Because if you fail to do anything about it, the Commissioner can take enforcement proceedings in the tribunal. If the agency's ignored the notice, there is also, and I think it's really important to know this, you've got virtually no ability to challenge what's happened. So if you want to say the Commissioner's got something wrong, get in there, apply for the variation, or get an appeal on the table. Don't just ignore it, because if you ignore it, the tribunal can only look at whether the notice has been fully complied with. That's your only excuse for not complying, which is really, really limited. So if you can turn around and say, but I've done it all, the tribunal will go, yeah, fair enough, that's fine. Actually, not tribunal, this is going to be district court enforcement, I think. Is it? No, tribunal enforcement. It is tribunal enforcement. Tribunal must not look in particular at how the notice was issued. They must not look at the merits of the notice. So you're not into some big legal proceedings where you can relitigate everything. It's not going to happen. The tribunal's jurisdiction is strictly limited. The remedies that the tribunal can give at the end of the day, whether to tell you to comply with a notice, for example, are discretionary. But I think you'd be barking up the wrong tree if you thought that the chances were high, that the tribunal would just say, yeah, all right, we know you got this order, but you don't really have to do anything about it. It's probably not going to happen. I'm not looking at my tribunal members over here. There's a range of remedies that the tribunal can give. Interestingly, again, it's not an excuse that didn't mean to do it, wasn't negligent, and that's very similar to what's under the Act now, right? It's not an excuse to say, I've partially fixed the problem, I've almost done it, Your Honour, unless there's no further reasonable steps that you could be required to take in order to comply with the notice. So the tribunal can kick in a whole variety of orders to tell you to do what you should have done in the first place, and can issue costs as they see fit. So I know we're almost at time, and I want to leave you a little bit of space. My particular summary is I think the powers do provide those teeth that we were asking for. There's some fairly forceful new powers in there, particularly to deal with those systemic cavalier breaches or where an agency flips you the bird. The checks and balances are important. They are there on the exercise of the power to issue. What I'd like to emphasise is that in my view anyway, and you may see this coming through some of my analysis on the slides, I think there is still a really strong role for voluntary action. Whether the Commissioner chooses to make compliance orders routine or not, I think there's still a really strong role for voluntary action. After all, if you voluntarily comply, then there's nothing to issue an order about at the end of the day. So you can still have that conversation, you can still exercise your powers of persuasion, you can still have that full right to put the facts as you see them in front of the Commissioner, and you can voluntarily agree to change your practice, and then there is nothing actually to issue the order about. And there are some real practical options in there if the agency disagrees with the Commissioner. So the Commissioner might not be the cute little puppy dog. The Commissioner might not also be the attack dog, showing all its teeth. Maybe it's a little bit more like this. It's the only Great Dane picture I could find. Those who know me well know I used to be a Great Dane owner. They came up to here, as big as me. Final point, though. Switching my metaphors. How will compliance orders work? There is a very, very large beast in the room, which is what happens about enforcement. Where do you have to go? Tribunal. Appeals. Where do you have to go? The tribunal. Anybody know what the wait time is in the tribunal at the moment? You knew I was going to go there, didn't you? Yeah, it's a couple of years, all right? I mean, the tribunal is really, really, really backed up. And partly because their chairperson has to sit on every panel, handle every teleconference. There is now a co-chair, which is helping to ease things up. But you have a massive backlog across 3 different jurisdictions, including the Part 1A Human Rights Act stuff, which takes forever in the tribunal. Really complex cases. It's not just privacy. So the tribunal is massively backed up. I think if you look at these processes, and you also look at the access determinations in the other section, where the complainant can kick things into the tribunal if somebody fails to comply with an access determination, you've got to be able to get through to the tribunal at the end of the day and get an answer. And at the moment, the tribunal is, for all intents and purposes, that the chairperson has said, basically not delivering for the vast majority of its parties. However much it tries, however much it's kicking that backlog, it's really, really difficult to get on top of. And now the privacy bill will deliver a whole load of new work into the tribunal. So not only there's process changes, there's a timeliness issue as well about needing to turn those things around. They will be relatively well formulated. It's a benefit. It's already been through the Commissioner's office. This is not going to be, lay plaintiffs. The Commissioner is going to be a party for the first time ever. It'll be Commissioner versus agency in the tribunal, which makes for a slightly different conversation than lay plaintiffs, which creates, again, sort of long delays in a lot of the tribunal processes, well as many of them act. It is hard. But I think that is the major potential hiccup in here, unless we resource our tribunal properly to be able to deliver on these new powers, the compliance system will actually fail.